Case on this morning's docket, Giovanni DeLuca, under two felony case numbers 22 CF 2056 and 2057. There's a waiver on file. We have received an offer from the state. Based on that, I sent a written plea agreement to my client. I expect to have back tomorrow for a plea and absentia. If we could just leave this on for the March 23rd date for control date, it is a plea to a misdemeanor, so he would be able to do that in absentia, and we should have a file at that time.
Continue to March 21st.
Thank you, Your Honor. That's all I have. If I may be excused. Thank you.
Sanders.
Good morning.
Good morning.
Rusty Sanders on behalf of Charles Allen Holly with an H. And the case was, I foresaw it being coming off the docket because he had entered into the PTI, but that does entail a plea, and there was one complication with an insanity defense that we had raised, but after our discussions with the state attorney's office, we're going to be able to accommodate that, and we've agreed to allow the case to be set on March 21st to be resolved, and that PTI stuff has already been submitted. So.
Very good. So we'll continue to March 21st.
Thank you very much.
Right, thank you. Have a good
yes,
day.
Sir.
Mr. Rare.
He's actually probably in the attorney's office.
Well, we can just go over him. When he comes back, just let him know. Ms. Merrifield.
Good morning, Judge.
Good morning.
First case I have is Shannon Bryant in 22 CF 1724. And Judge, I have a written plea to misdemeanors if I may approach.
You may.
There's a signature on the top.
Thank you very much. Anything from the state on this? Good?
Yes.
Thank you very much.
And Judge, the last case I have is Jack Hunter in 22 CF 2484. There is a waiver. Mr. Hunter was set today as a control date for return of his pretrial intervention agreement. It's my understanding that that has been sent to the diversion office, but they have not yet had an orientation, so it hasn't been scheduled. If we could set this off for another control date, it should naturally fall off the docket. I would think that Officer Perez would need about a week or two to get that taken care of.
Do you want to do March 21st date? Is that when do you want to try?
If we could set one just a little bit after.
You want to just do a regular pre-trial?
Absolutely.
Next pre-trial? Okay, so our next pre-trial is February 13th.
4/13?
4/13. No, let's see. It's not February. April 10th.
April 10th. Thank you, Judge. It should fall off before then. That's all I have this morning.
Thank you.
Thank you.
Mr. Arrowwood.
Good morning.
Good morning.
Jeff Arrowwood representing Micah Chase Hagan, 2019.
Hold on, you're not on in my alphabet. What is your client's name?
Hagan, Hagan.
number for us?
Yes, sir, it's 2019 CF 423.
I'm showing David.
I got it, I found it.
He was the
It was an
original.
old case, it was amazingly on our docket for some reason, it was showed up as Oberlisa.
And he was the original one, I believe.
That's all right. You just go by alphabetical by the attorneys, and if you get out of place, it's hard to find.
Yes, sir, may I approach?
You may.
We filed a motion, that's my phone. We filed a motion to terminate probation early for my client. We contacted the probation officer. The probation officer has no objection. I wanted to get in writing, as this court's aware, generally they don't really do that, but they did in this case. Mr. Cook was Cook. I have another client with the same, his name's Cook. Mr. Hagan was put on probation September 3rd of 2020, and he's followed all the obligations, his payments, his mental health evaluation, screening, counseling that he had to attend, as well as paying all court costs. So originally it was 60 months. He's been on for now 30 months, and he's asking the court, because there's been no violations and no objection by the probation officer, that he be allowed to terminate early, Judge.
What's the state's position?
Your Honor, the state is objecting based on the nature of the charges. We were not able to get a hold of the victim to get their input on the case, but based on the fact it's a felony battery and it involves some mental health diagnosis, the state is just not in a position to agree at this time. He did enter into a contract with the state for the sentence. I apologize.
Slow down a little bit, slow down. I'm not hearing you, you're not coming through the microphone.
Okay. Let me see if this is better. Thank you, Your Honor. He was sentenced to 60 months. He pleaded to a felony battery, but it did start as a sex assault case, Your Honor, and this involves some mental health issues. The state is not comfortable agreeing to an early termination at this time, and would be more comfortable if he went through his 60 months of probation to guarantee that he does continue with his mental health treatment as he was ordered. Furthermore, we have not been able to get in contact with the victim to see what the victim thinks about an early termination of probation. So based on Marcy's law, we would not be in a position to agree at this time.
And just the best person to know if my client is in a position to have it terminated would be the probation officer, who's had one-on-one contact since the beginning of the case and has followed him through his mental health evaluations and tested him for drugs and alcohol and so forth. And like I said, he's never been violated. And the probation officer, Tiffany Rose, has no objection. And again, that's why I wanted proof to hand you, Judge, to show you that it wasn't just what I'm asking you or telling you, but the probation had no objection. And I am a little familiar with this case because I almost had it from the beginning, even though it started out as a sex case. We don't believe it should have been filed as that, and ultimately it was pled down, which it probably should have been. But that's where we are, Judge.
Here's what I'm gonna do. I think, has the state tried to get in touch with the victim? I'm not saying, I mean, are you having trouble what I'm thinking about doing is at least delaying consideration until, at the very least, you can contact the victim.
Thank you, Your Honor.
I don't want to, if you've been trying and like, look, we found her or whatever.
My victim's advocate hadn't gotten back to me, but I had sent a request that she contact her. She's very, very good about letting me know as soon as a victim calls back, and the victim just had not called back yet. I believe she tried last week.
Okay. Why don't we come back on the 21st and just continue this? We'll continue to 3:21 in the morning.
Yes, sir. Thank you. That's all I have. I'm excused.
Thank you. Mr. Durrell?
Morning, Your Honor. Your Honor, the first case I have should be on the docket as Connor LaRose, I believe, AKA James Connor. He is present and approaching, Your Honor.
She just stepped out.
Well, I've had conversations with Ms. Sharpless. This is the one we've been trying to get a video from Shalimar PD for forever, Your Honor, and apparently it just does not exist. I believe we may be close to a resolution. I believe Mr. Connor set for the 21st. I understand this is getting old, and Mr. Connor wants this over just as much as the court does, I'm sure. Typically, I like to watch the video before I schedule depositions. Again, there's been no video, so if we can't resolve this, we may need to move forward with depositions. And again, I understand it's super old, but that's just, we've been trying to get the video for so long, and I don't know what's happened to it, neither does Ms. Sharpless. I know she submitted requests.
Is it your understanding, Ms. Sharpless, that Mr. Drell came to the conclusion maybe it doesn't exist? Is that the same conclusion you come to, or is this? I mean, we're not dealing with lack of cooperation here. We're dealing with just, hey, there really is a problem that may have been whatever.
Your Honor, Shalimar Police Department's a small agency, so yeah, it's touch and go whether there might be video, and I have been in contact making requests trying to get this video because I know.
When you say there might not be video, it's like that they didn't. I don't know all the circumstances of this. I don't know what video are we talking about?
This is
a video cam and a.
This is allegedly an allude, Your Honor. My recollection of the arrest report states that there is body cam footage of the Shalimar officer that is alleged to have identified Mr. Connor as the one on the motorcycle that fled from him. There's also reference to involvement by Okloosa County Sheriff's Office and Walton Beach PD. None of those officers have been listed or we have body cam for. If we need to do the deposition just to find out if there is body cam and who is involved, we may need to get that scheduled. But I hate to do it because I know it's so old, but I think I have to just to protect my client's rights.
I understand that. I can't. You've got to do your discovery, and the discovery is missing in some where we can't determine where there is discovery, and that's legitimate, even though we're all wanting to move these cases.
Yes.
So I'm a little worried to come back on the 21st of March. Seems to me that we ought to maybe just come back for our regular pretrial.
We can do that, Your Honor. The only reason I suggested the 21st is just in case we can reach a resolution. We may be close. I don't mind coming back next Tuesday if we can get it done. Great. If not, then we'll proceed with the discovery.
Okay, so we'll continue to 3/21.
Thank you, Judge.
Thank you, Your Honor. I'll let you know. Next, Your Honor, is Mr. Matthew Allshouse. I believe we were looking for discovery on this matter as well. It has come over. I got it downloaded yesterday. I haven't had a chance to review it fully. I'd ask for a continuance to make sure we've got everything we need.
How long do we need to?
We can leave him set for the 21st as well, just to make sure I've got everything. We'll be here anyway.
Yeah, but we're filling up our time. If we don't, if it's not, we don't need.
No, I
we have on the 21st at this point.
And Your Honor, I believe the last time was his first time up.
That's
I-
really it.
I'm sorry.
You're at 21.
Okay.
This one is still relatively new. If we can have a continuance, I imagine I'll need to conduct depositions after I review the video as well. So.
Well, then why don't we come back for our next pretrial?
Sounds great.
So we'll come back on 4/10.
Thank you, Your
Continue
Honor.
until 4/10.
And I believe that's all I have.
That's all you got. Thank you.
I'm sorry, Judge, what date did we put this on?
4/10. 4/10.
Okay, thank you.
Thank you, Your Honor.
Parnell.
Good morning, Judge.
Good morning, Mr. Parnell.
Troy Parnell.
Hold on a second, let me find your. I don't have your name.
CREEL.
Thank you.
Yes, sir.
Thank you.
Trey Parnell on behalf of Jessica Creel. Judge, this is a PTI referral. I was speaking to probation this morning and gave them a copy of the agreement that I'd received from Ms. Sandler. And my client lives in Louisiana, so Officer Barres is going to be sending a copy of that and reaching out to her and getting her signed up for PTI.
Okay. Do we need to have kind of just a status date, just to make sure it doesn't fall off and get lost in the shuffle?
Just like a control date to get her signed up.
Yes. How long?
I would say 2 weeks.
I would agree with that.
What do we have on April 11th at this point? We can either come back next week or we can come back in a month.
I would say April 11th, and then it should fall off the docket.
Very good. We'll continue till April 11th.
I don't know why April 11th sticks in my head. Yeah, Your Honor, I have to be in Bay County on that day for Dr. David Judge Clark.
You always come back for pre-talk, and you come back here the day before that?
Sure. If she does successfully get signed up, can we just notify the court and have it removed from the docket, or do you want to see me on the 10th?
Yes.
Okay.
Very good.
Thank you, Judge. The other matter I'm covering for Bo Powell is Pierre Andre Roach, R-O-A-C-H. Mr. Powell got on that case.
Hold on. Not on alphabetical.
It's 2 VOPs, a felony and a misdemeanor case.
What's that? Is there a waiver on file?
Mr. Powell got on the case yesterday, so I'm not sure if there is a waiver or not. I did share a positive.
What's the defendant's name?
Last name is Roach, R-O-A-C-H. First name Pierre.
Got it.
Okay. We would ask that the public defender be allowed to withdraw. Mr. Powell has told me he's on it.
Just give me some paperwork and we'll get a substitute.
Okay, very good, sir.
Would you let Mr. Powell know he hasn't wanted to really come on?
I will certainly let him know.
So what are we doing on this?
Mr. Powell just got on it. It's not prepared to move forward today, so we just ask for your next VOP appropriate date.
State?
Your Honor, considering the pending order revoked the bond, I'm going to ask for a quick turnaround so that defendant can appear to be taken into custody.
Supposed to be here today.
Well, I agree. So I did see COVID test results. Judge, you can take that as you will.
That was presented to, I'm not aware of that.
Judge, Mr. Powell yesterday, when I told him I was going to be here and I would cover this for him, had gotten paperwork from Mr. Roach getting him on the case, but he also sent a positive COVID result, which, if I recall correctly, is
For his client or?
for the client, Mr. Roach, and it was dated. I can show it to the court. I have it on my phone if you'd like to see it, but I've shown it to the state.
And you're an officer of the court, I trust you.
Yes, sir.
Okay.
So, Your Honor, I believe you have a
That's
docket
what I need to know.
I believe you have a docket on the 21st. Is that correct? Would you be comfortable saying it for that date?
Sure. We'll continue this till the 21st of March.
And what time is that, sir?
In the morning. Not in.
Very good. Thank you. It's good to see you.
Thank you. Yes, sir. Mr. Stewart? I'm sorry?
Can I pass one on here?
Sure.
Who?
Ms. Reed?
Thank you, Judge. I am covering for Mr. Cotton.
Okay.
Let's see, the case number is,
20 CF 3126.
yes, Ms. Leah Clayton.
Correct.
She is a PTI recall, but I believe my office has supplied Ms. Sandler with some proofs of completion on her certain courses, proof of payment. The only thing she has outstanding is 24 hours of community service work, which the state has agreed to let her buy out. So if we could just put this on the court's next available miscellaneous date, and that we can provide proof of payment, and then hopefully all the requirements will be completed and the state can issue a no clause.
State?
The state's fine with that, Your Honor. She has provided a certificate of completion. She's paid her court costs as well.
Very good. We'll continue until March 21st.
March 21st. Is that at 9 a.m., Your Honor?
Yes, ma'am.
Okay. And next, I am covering for Mr. Shaw. Clayton Forster, I believe. And I believe that that is Ms. Sharpless's case, and my understanding is that the victim filed a drop charge request and that the state was filing a dismissal this morning of the charges.
I'm sorry, I'm on.
Clayton Forster, the Tim Shaw.
Fortson.
Case number
Fortson.
22 CF 2399.
That's actually Ms. Sandler's case, sorry.
Oh, okay. Apologize. It's okay.
Take your time.
This is a violation of probation. Your Honor, if I may have just a moment.
Sure.
Yeah, Clay.
Your Honor, I received a drop charge affidavit from the victim in this case, and the state will be filing an old file. So we've announced one today, and we'll get one filed.
Very good. Thank you very much.
And I'm not covering for anyone else. That concludes my business before the court. I apologize I was late this morning, Judge, but I found out at about 8:45 that I'd be in court this morning, so may I be excused?
Sure, all your fellow lawyers appreciate your efforts.
Yes. May I be excused, Judge? Thank you.
Mr. Rear. Is it rear or rare?
It's rare, Judge.
Rare?
It's a weird
I
spelling for
always-
such an easy name, I know.
I'm sure everybody calls you rear all the time, but.
About 80% of the time until they learn.
Well,
but thank you for
I try to
asking.
get people's names right, but
I appreciate you for asking,
not
Judge.
particularly good with names myself.
No, I gotcha. Judge, Mr. Joshua Nelson is with me. The state's reviewing that, Judge. Mr. Rogers is signing it.
Well, so I'm removing.
Right, I understand from the conversation. Judge, we reviewed the written plea agreement with the state, and he's signing that now. Thank you for that approach, Judge.
Would you announce the plea agreement?
Yes, Judge. In 20 CF 461 and 20 CF 623, Mr. Nelson wishes to withdraw his previous interplea of not guilty, ignorant admission of the violations. There would be an adjudication of guilt, revoking terminating supervision, $150 VOP fee in each case, 9 months Okloosa County Jail concurrent, and concurrent between the 2 counts, and that would be a downward departure sentence.
State's agreement, Judge, said downward departure based upon a legitimate unenforced plea bargain.
Mr. Nelson, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes, sir. Okay. So you just heard your attorney state the terms of your plea agreement, and I'm looking at a written plea agreement that appears to have your signature on it. Is that inaccurate? Is that your understanding of what the plea agreement is?
Yes, sir.
And you're in agreement with that?
Yes, sir.
You understand that this is the final resolution of this violation of probation, and actually, in this case, your probation will be revoked and terminated as well. So that means basically when you finish serving your sentence in the county jail, you're done.
Yes, sir.
Right? You understand that?
Yes, sir.
Is that your, you believe that's in your best interest to do so?
Yes, sir.
And you've had all your legal questions answered of your attorney about this plea agreement?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept the plea agreement, and there'll be an adjudication of guilt, revoke and terminate probation, sentence the defendant to 9 months in the county jail for each charge. They'll be served at the same time, concurrent. You will get credit for all time served, and there's the $150 fees times 2. Okay?
Yes, sir.
Any question?
Yes.
Okay. Thank you.
It should just be on each case.
Should just be 100 each day.
150 assessed a single time?
No, just $100 state attorney fee, which is a DOT fee for each case.
Yeah, you had 150 for each. It should only be 100.
Well, I don't think we're going to object to tweaking that then. Save you $100.
Okay.
I just didn't know.
And I appreciate you catching
State
that.
okay with that? That the fees are just 100 rather than 150?
Yes, Your Honor, that's fine.
Okay.
And how much time you pay?
If the judge gives you 90 days from date of release to pay, would that be okay?
Yes, sir.
Okay, very good.
Yes, sir.
Okay, thank you.
Next, Your Honor, I have is Ms. Jaya Dial, 22 CF 1614. Ms. Dial is presently approaching. And Judge, this is going to be a plea into the diversion program. Hey, one moment. Permission to approach, Your Honor.
Thank you. Would you announce the plea?
Yes, Judge. In 22 CF 1614, Ms. Dial wishes to withdraw her previously entered plea of not guilty, enter a plea of no contest as charged. She'll be entering a plea into the diversion program where sentence will be held in abeyance while she has time to complete that. It's a 10-month PTI program. And we may need to have a control date, but the paperwork should be filed here this week, and she'll meet with Ms. Varese in the PTI program to begin serving that.
So there's no document yet that's been signed by all parties? Oh, okay.
And that's the plea. We have the PTI, but we'll have to e-file that to Ms. Varese so she can draft the final contract.
I'm sorry, say that again?
My understanding of the state is we have the plea entered today while she enters the diversion program. We have the diversion terms signed
Right.
by the state in Ms. Dial.
Right.
The final signature with PTI, she'll have to meet with them in person and sign the rest of the documentation there. It'll get e-filed and then should fall off the court's docket.
Okay, very good. The state in agreement with this?
Yes, Your Honor, that is the state's agreement.
So, just so everybody's aware, I want to make sure this is clear for the defendants, mainly for the defendant's benefit, but I think I understand the answer. What occurs if the defendant does not successfully complete the PTI program?
If the diversion program is violated, she would come back to the court for sentencing.
Okay, so there would basically, the first, essentially what this is doing is you're you're pleading no contest. So you can't come back and start the whole process all over, and they're basically proving their case against you by entering this plea agreement. Do you understand that? So the resolution of the first part of the process. I don't know that I'm explaining it properly.
And I've gone over with her, Judge. If diversion is completed, she may withdraw her plea. All charges will be dismissed. If she does not successfully complete by violating the conditions of diversion, the recourse is to come back to court and she will be sentenced by this court.
Okay. You understand that?
Yes.
Okay. Did I swear you in? I don't think I did.
I don't believe so.
Would you raise your right hand? I need to swear you. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
So this is this is a good program because you can put your hand down. Because obviously, if you complete the PTI program, you can get your charges dismissed. That's obviously a huge benefit to you. But it also puts a lot of responsibility on you, because if you don't, they come back and they go right to sentencing, which means you could, not saying you will, but I'm saying you could face jail time. You understand that?
Yes.
Okay. So you're clear about the terms of, I don't have the pretrial intervention terms in front of me, but you're clear about what those are, and you've gone over it with your attorney, make sure you're comfortable with those?
Yes.
And you understand that this will be a final resolution of that first part of the case by entering into this. You can't come back and revisit this.
Yes.
Okay. And you've had a chance to go over kind of what this means to you legally with your attorney, make sure you had all your questions answered?
Yep.
Okay. Very good. Based upon that testimony, the court will accept the plea agreement. The defendant will plead no contest, and the sentencing will be held in abeyance while the defendant enters and completes the pretrial intervention program. Upon successful completion of the pretrial intervention program, the defendant may withdraw her plea, and the charges shall, and that's a must, be dismissed. But the converse of that is if you don't, you come back for sentencing.
It goes back to the, well, is that a plea and sentencing?
Yes.
That's the plea and sentencing. We still have the PTI. We'll give that to diversion. Correct.
Did you want a control date for the 21st just in case? She has to meet with them, right?
Correct. I'm fine having a control date, but it should fall off the court's docket once she meets and signs.
How long before? If we come back on the 21st, does that get us there?
Do we have
you want to do it April 11th?
That's probably better, Judge, just to make sure.
April 11th. Okay. Any questions?
No, Judge.
Thank you.
All right, thank you, Your Honor.
Who's that, Mr. Patel or Mr. Stewart? I don't know who came
Good
in.
morning, Judge. Jay Patel on behalf of Jeffrey Brower. We put it on this docket in hopes to have a resolution. We're not quite there yet. I asked that this be placed on the next pretrial docket. He had his first pretrial just a couple of weeks ago.
Okay, we'll continue this to the regular pretrial on 4/10.
Thank you.
He's not incarcerated, right?
He's not. Do you have any excuse? Thank you, Judge.
Mr. Stewart.
Good morning, Your Honor.
Good morning.
May it please the court, Brad Stewart, on behalf of Irvin Westbrook, Your Honor. Mr. Westbrook is incarcerated. If I may pause for a moment. Your Honor, Mr. Westbrook is present before the court, Judge. If we can pass this to this afternoon. Our Assistant State Attorney is not here at the moment. We do anticipate resolving this matter this afternoon.
Your Honor, Ms. Basso does have this case, and she did indicate, she didn't give the specifics to me, but but she did indicate what she'd be willing to do in general and asked me to let Mr. Stewart know that. And she indicated that if he wanted to leave it on this afternoon, she would be here, and that if that's something that he thinks he can get done today, that she would be willing to go ahead and close this case today.
Okay.
1:30?
If you can.
Right, Mr. Westbrook, not to be at 1:30.
1:30.
Very good. Gentlemen, may I be excused until that point? Thank you.
Thank you. Is Mr. Garrett here today? Attorney Garrett? Also, Mr. Madden is
I think Mr. Madden did a written plea of not guilty for Mr. Buchanan. I have spoken to him.
would you, is that your case?
It is my case, Your Honor.
Can you check on that? I've got it down as a VOP evidentiary, which means that there's already been a plea made on evidentiary for Mr. Madden, the one I've got. What case are you talking about?
Jamel Eva.
And yes, there was a denial entered on February 14th, and he put it on today.
But we put it on this morning, which makes me think it won't be, it's not going to be an evidentiary hearing.
No. I understand that, but the way it goes into the file, when it says evidentiary, and we've had this discussion, it means that there's been a previously entered plea. This isn't the first up for a VOP.
Yeah, yes, I
in which
understand.
we take the plea.
I can message Mr. Madden and see if he's been in another courtroom or
Okay.
something. Because I did speak to him about this case, Judge.
Okay. And there's a couple of people that are on my docket for this morning that have no attorneys. Let's see if we can see if they're here. Sonia Greco. State?
State would ask for a KP, Your Honor.
Court will issue a no bond capias. How about Andrew J?
Yes.
I'm sorry?
Yes.
Would you come to the podium, sir? Would the state go ahead and announce the case?
Yes, Your Honor. This is case 22 CF 2230. Mr. J is before the court on 3 misdemeanors, all traffic related, for which he was on probation. There's an allegation that Mr. J has failed to complete the requirements of his probation by failing to pay court costs and failing to obtain a valid Florida driver's license. The state would be willing to dismiss the alleged violation of probation if Mr. J were to pay the outstanding costs and acquire his Florida driver's license or show eligibility.
Okay. So they're basically making, you're here on a violation of probation.
Yes.
They're basically making you an offer to plea that out and dismiss the violation of probation. You do have a right in this case to have an attorney appointed. If you are uncomfortable, kind of don't understand what's really going on, which would be understandable, I can appoint you an attorney, or you can hire a private attorney, and then we can come back and the offer, I'm sure, will still be on.
Yeah, I'm working on, I got DUI school completed and.
Right. So how much money is?
It looks to be about $1,000. Your Honor, perhaps you want to inquire how much time Mr. J would like to try and get his requirements done.
Yeah, I need a couple more months because to get my driver's license back is like $1,200.
Right.
Your Honor, I'd be fine pushing this 90 days.
Okay. Why don't we just go ahead and, so there's a VOP, you're not being appointed an attorney. We're gonna set this out 3 months. We're gonna continue this hearing today.
Yes, sir.
Essentially.
Okay.
We're gonna go out 3 months, you gotta come back, but if you get it resolved in the interim, they'll dismiss it.
Yes,
You
sir.
gotta get this dealt with, so that you don't have to deal with the new case and a violation.
Yes, sir.
Okay, let's see, when the 3 months.
June.
June 13th.
22 CT 1372 was also put on probation in this case. Your Honor sentenced him with this county court case as well, and no VOP was filed on the 22 CT 1372. So I just thought that I would bring that now, and there is a dismissal, this case is still hanging out there.
Did you hear what she said?
I am hearing. I can only deal with the cases that are before the court for now. I can certainly look into.
Okay,
the
yeah,
issue
you just wanted to make aware so we can try and make sometimes, you know, when we have county and felony courts, there are actually 2 judges, and we sometimes don't see I don't automatically, unless I have
Yes, sir.
a very conscientious clerk that will kind of bring it to my attention, I'm not seeing that in there. We want to try and resolve everything at one
What's
time.
hanging?
There's something in county court. I don't know what's in county court.
So that's accurate. I'm seeing, Mr. J, I'm seeing that you have a case, 22 CT 1372. Those also looked like, looks like there was a plea to operating a motor vehicle without a valid license. So what I'm going to do is just look up your plea agreement.
Yeah, that was all run together.
And let's see, and it does look like you were placed on probation in both cases. So the state's offer is the same, essentially. Just make sure you get your costs paid and show up.
What you need to do is make a note in your mind to make sure that if this is resolved, when you come back, I'm going to have a court date on 6/13, June 13th.
Yes,
Okay?
sir.
And when you come back, you ask about that and make sure that that's a part of this.
Yes, sir.
But I'm not going to it's not going to automatically tag me.
Okay.
Okay, so
Yes.
if you want it all resolved, you make sure and raise it, and it'll kind of bring it back to our attention.
Yeah, because both of those was run together. So.
Well, they're not running together.
Okay.
You might think they should, but they don't.
Okay.
They don't always run together. I don't know exactly why they're not in this case. A lot of
Yes.
times we do have misdemeanors to run. I'm not exactly sure why they're operating separately, but apparently there's already been a plea in the county court. I don't know exactly what's gone on, but just make sure. Come back June 13th, get everything resolved, but still come back.
Yes, sir.
Hopefully by that time, the state's offer, they'll dismiss it, you gotta get this stuff done.
Okay. Thanks, sir.
Thank you. Okay, Christopher Wilson is also, you come forward. Would the state announce violation of probation?
Yes, Judge. Judge, this is case 21 CF 860. Mr. Wilson is before the court on an alleged violation of probation, on a charge of possession of controlled substance. The allegation is that Mr. Wilson has committed a new law violation. Looks like it is alleged that occurred in Santa Rosa County. Typically in situations like this, I would wait to see what occurred with the new law violation. Essentially, if Mr. Wilson intends to enter a plea to that case. As of right now, if Mr. Wilson wished to enter a plea, the offer would be incarcerative in nature.
Why don't we go ahead and sir, you've got a violation of probation in this case based on
Yes, sir.
something happened over in Santa Rosa County.
Yeah, that's where I live.
So, you do have a right to have an attorney appointed in this new case?
I'd like to have one.
Okay. So what I'm gonna do is I'm gonna appoint the public defender, and I'm going to issue a denial on your behalf so that you don't give up any of your rights. You can follow up with your attorney. We'll come back. Why don't we give it a little time to see where we're going in this case? At least a month or
Yes, sir.
month. Does that sound about right?
We can try that and just see what happens.
Why don't we say April 18th, 4:18 in the morning, without speaking.
Thanks, Judge.
So that's all. Yeah, we'll do regional. Any other private counsel out? Okay. Mr. Harper, you want to do your cases?
Do you want me to go forward with my out of custody first, sir?
Let's just go down the list.
Okay, the first one I have, Judge, is Chandra Beard, number 22. And she is present and approaching. She is before the courts on 22 CF 1941. Judge, I'd hope we are be able to resolve this today, but I don't think we're able to come to terms. If I can set this for 4:10 for pre-trial conference.
Very good. We'll continue this to 4:10, 9 a.m. Shea Carter.
Shea Carter. That's 3:15:23.
Would you announce?
Yes, Judge. Rudy Harper on behalf of Ms. Carver. She's before the courts on 22 CF 2723 and 21 CF 2002. At this time, she's going to withdraw her previously entered plea and enter a plea of no contest, as well as an admission as to the violation of probation. On 22 CF 2723, this will be a plea as charged, adjudication of guilt, 9 months in the Okloosa County Jail, credit for all time served to run concurrence. That will be followed by 2 years of probation, $515 in court costs, $150 cost of defense, 10 to complete a substance abuse evaluation and any recommended treatments, perform 50 hours of community service work, no contact with Stephanie Mullings and or TTF, which is a minor, 10 to complete anger management class, no trespassing at 607 Virginia Oak Court for Walton Beach, maintain employment or 5 job applications per week, and no weapons or firearms during supervision. With respect to 21 CF 2002, and it'll be an adjudication, revoke and terminate, roll over the outstanding requirements to 22 CF 2723. Your Honor, if we can, I think she's just going to finish up the score sheet and file that later on this morning. If I may approach.
Okay. Thank you. So is the state in agreement?
Yes, Your Honor, that is the state's agreement, and I do have a score sheet. It is handwritten. I apologize for that, but I don't want to forget about that. So
Ma'am, would you raise your right hand? I just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
yes, sir.
You So you heard your attorney state the terms of your plea agreement on both of these charges, the underlying, the new law charge plus the violation. And I see that you have signed the written plea agreement that says the same thing. Is his rendition and what's contained in here, is that what your understanding of the plea agreement is?
Yes, sir.
The main thing I want to make sure is that you understand what you're doing and that you're entering into it freely and voluntarily. So my first question is, have you had a chance to go over in detail this plea agreement and all the other terms in this written plea agreement with your attorney and make sure you understand it?
Yes, sir.
You believe it's in your best interest to enter into this plea agreement?
Yes, sir.
You understand that by entering into this plea agreement here today, you're waiving the right to go, you're waiving some valuable rights. The right to go to a trial, confront witnesses, etc. Do you understand that?
Yes, sir.
Do you think this is in your best interest to enter into this plea?
Yes, sir.
And you have had all your legal questions answered by your attorney?
Yes, sir.
Okay. Very good. Based upon that, the court will accept your plea agreement, and in 22 CF 2723, there'll be an adjudication of guilt, 9 months in the Okloosa County Jail. You will get credit for all time served, and this will be followed by 2 years probation. There's some fees and costs, and you must deal with some substance abuse evaluation. That'll be during the terms of your probation. You comfortable doing that?
Yes.
Okay. And importantly, and I always raise this because I hate when there are violations relating to this, but everybody takes this real serious. This no contact, because I don't always know what the relationships are. Sometimes they're a little tricky. The no contact here is one-sided no contact. That means you got to stay away from them,
Yes,
even if they approach you. Do you understand that?
Mm-hmm.
Okay, and the same with the no trespassing. Got to stay away from that.
You'll never have to worry about it.
Okay, very good. Okay. With that, the court will accept your plea agreement. Good luck.
The outstanding requirements are rolled into.
Yes.
Yes, ma'am. Your Honor, if I can call Aaron Davenport next. He is present and approaching. He's before the court on 22 CF 1976, 22 CF 2341, and 22 CF 2401. Judge, I spoke with him this morning and conveyed to him the offer from the state. He's advised me that he's asking for some time to seek private counsel.
Okay.
So I'd ask to set this for the 4:10 pretrial conference.
Very good. The court will continue this to 4, 10, and 9 a.m.
And the last one I had this morning, Judge, is Cameron Haynes. He is present and approaching. He's before the court on 22 CF 1416 and 22 CF 3159. Judge.
Who's on that prior case, Davenport?
That's my case, Your Honor.
If he doesn't get private counsel, you need to let him know we're moving forward with this case. You need to be prepared to move. This
Yes,
case
Your
is
Honor.
almost a year old.
I understand.
That's fine, Judge.
I want to make sure he's aware of that, and that we're not just going to be twiddling our fingers on it.
And Your Honor, I don't disagree. One of these cases is, at least one of these cases is from last summer. However, there is a new case that he just got arrested on recently. So I just want to make sure the court.
And what recently? I've got the most recent case is August of last year, which is not a year old, but it's
The 22 CF 2341. It looks like he had first appearance initial appearance in October of 2022. So it's not as old as the other cases. Just so the court understands.
okay. It's not brand new, but it's.
Full disclosure, we're very close to a plea. I think there was one term that was throwing this to a yes or a no.
Okay.
With respect to Mr. Haynes, Judge, 22 CF 1416, 22 CF 3159. Judge, the state sent me over a PTI agreement The only issue is that the restitution amount in that PTI is $10,000. So I just need to clarify with Mr. Haynes that that's something that's financially possible within that time frame, and whether or not that restitution amount is accurate. And so I'd ask to set this for 410. I'll be speaking with the state as well as Mr. Haynes to see if we can come to an understanding of whether or not that's an accurate number.
Okay. Very good.
Okay. Thank you, Judge. That's all I have today.
Mr. Gates, you want to do a couple of yours?
Yes, Sharon, I can do my 2 out of custody. I'll start with Rebecca Farakis. She's the number 28 on the docket, Your Honor.
Okay.
Ms. Farakis, well, I'll pass her. She's been in and out of the courtroom, Your Honor. She's had some medical issues. The state and I talked. We're going to bring her back next Tuesday at 9 a.m. for the plea.
Okay.
Rebecca Farakis.
Okay, when is she coming back?
Next Tuesday at 9 a.m. for a plea, Your Honor.
Continue this till 3/21.
And then my last out of custody, and I see Mr. Madden's here, is to be Zachary Howard, Your Honor.
Okay.
Mr. Howard should be number 31 on the docket.
Correct.
And we have a plea agreement to be filed in Mr. Howard's case, if I may approach.
Need I review this court sheet before you already know the actions of that?
Thank you.
This will be a downward departure for the negotiated plea agreement.
Did you announce the plea?
Yes, Your Honor. Thank you. Will be a plea as charged. Mr. Howard will be adjudicated guilty based on 36 months of probation. We're going to ask the court to waive the cost of supervision, assess the standard court cost of $866, $150 public defender fee, required to take an anger management course, no violent contact with Mr. Michael Howard, and no objection to transferring the supervision to Duval County where Mr. Howard resides.
The state in agreement.
That is the state's agreement, Your Honor.
Mr. Howard, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea and sentencing agreement that it appears that you've signed.
Yes, sir.
Is that your understanding of what the plea agreement is?
Yes, sir.
And you believe it's in your best interest to enter into this plea agreement here today?
Yes, sir.
You understand that by entering this plea agreement, this will be a final resolution of your case?
Yes, sir.
Waiving the right to go to a trial, it's a final resolution.
Yes,
You
sir.
understand that? You had all your legal questions answered of your attorney?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea. Will be an adjudication of guilt, 36 months of probation, various fees and costs, waive the cost of supervision. This anger management course, he'll have to do it over in Duval County. I'm sure they've got plenty of those over there. No violent contact with Mr. Michael Howard, and of course the transfer of the probation that'll be dealt with by probation. Any questions?
No, sir.
Thank you. Yeah. Did Mr. Madden show up?
Yes, Your Honor.
You ready? You want to go?
I apologize, Your Honor. I was in Walton County this morning.
That's all right.
I had my office call yours, but I don't know if that was communicated to Your Honor.
No, it was actually, but
So I got over here as quickly as I could.
No, I'm not. We were just looking.
Okay. If I could just have a few minutes, Your Honor, I'm talking to the state and my client, and I should be ready shortly.
Okay.
Thank you, Judge.
Judge, I have one out of custody if I could.
Sure.
Dawn Wire.
Ms. Byers is number 35 on your docket, Judge. Case number is 22 CF 1606. Ms. Byers also has a new law violation that's set for felony plea day this afternoon. She is on page 3 of that docket. Oh, yes, I'm sorry. Charles Russell, Public Defender's Office, covering Ms. Deaton Dean. Sorry. Yes, ma'am. Okay, so on the VOP, Judge, what we're going to do is enter a denial, and then on the new law case, 23 CF 341, state has filed an information. We're going to go ahead and enter a plea of not guilty, request a trial by jury, and 15 days to file any pre-arraignment motions, and ask that both cases track to your next pretrial conference, which I think is April 10th.
That is correct. So we'll enter the denial and not guilty pleas, and we'll come back on our regular pretrial on April 10th at 9 a.m.
Thank you.
Thank you.
That'll take care of that this afternoon too.
Okay. Who wants to go? Mr. Gates, Mr. Morrow? It's up to you.
Yeah.
I can call a few of my in custody, Your Honor, if they're up.
I'm sorry?
I can call a few of my in custody.
We'll do the window first and just go down the road.
Yeah, we'll just go down. We're ready.
Can we start looking at in custody?
Sure. Which is the first one you want to do?
We're going to do the female first, Georgiana Halls.
What number is that?
Ms. Halsey should be number 30.
No, that's good. I just, there we go. I had to find it on my back. Mr. Gates?
Yes, Your Honor.
Oh, I'm sorry.
Yeah, this is Ms. Halsey before the court, if I can have a second. Your Honor, I met with Ms. Halsey yesterday. We went over a plea agreement. I left it with her to review. She was told me this morning she's ready to sign it. It will incorporate case number 23 CF 440 and 23 CF 449.
That's for everything. No, that's for here.
Okay, that's fine. I'll put it in my file.
Chairman, approach? Yes. And I forgot I was associated with all of these.
It's a closed case.
Your Honor, Ms. Halsey and I were discussing the score sheet. She does have a VOP based in Escambia County, and I've explained to her that the plea here would be part of the violation there, but my expectation is that likely the score sheet wouldn't include these charges as primary because the Escambia County case is only in front of that judge for sentencing. The worst case scenario would be its prior history if the state decides to even put those on the score sheet. And that's where she and I were having that conversation about the score sheet this morning, right? Okay, you good? Yeah, Ms. Halsey is going to enter a plea of no contest as charged in both cases. It'll be adjudicated guilty on all counts and cases. And 23 CF 440 should be sentenced to time served. Standard court costs and PD fee, Ms. Halsey's asked for 24 months to pay those outstanding fees. And 23 CF 449, time served. Standard court costs, PD fee, again, 24 months to pay those outstanding court costs. And then an abundance of caution, I included that she was doing this knowing that that would be incorporated into the affidavit in Escambia County as well on those case numbers. State?
That is the state's agreement, Your Honor.
Ma'am, would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
So, heard the attorney state the terms of your plea agreement, and those same terms are reflected in your written plea agreement that you've signed. Just want to make sure you understand what it is you're agreeing to and that it's freely voluntary. So, you understand you're getting credit for all time served, basically the time you served in the county jail. And mainly this plea is about a lot of court costs and fees. You'll have 24 months to pay those. And then it'll go to collections if you can't pay them in that period of time. Do you understand that?
Yes.
Have you been able to go over this? This does have some legal impact potentially on what's going on in Escambia County. Just want to make sure you've gone over how your legal questions answered by your attorney.
As best as I'm going to get.
I'm not sure that's what that means.
I don't either. I just know that I just need to get to Escambia County.
Part of the issue, Your Honor, she's asked about the score sheet in Escambia County. And the way Escambia County does, the clerk website does it, is if there's an active capias, they block the case out, so no one can access it. And I've explained to her that I've tried to get the score sheet. Unfortunately, I don't have access to it. And so that's part of the issue. She's concerned what she might be looking at in Escambia County.
And how this might affect?
Yes, Your Honor.
Okay. So there's a little bit of uncertainty. So are you, I don't want, here's the thing. I don't want you to feel like you're being pushed into this and then some result over in Escambia happens and you go, I didn't realize that's what was happening, that it would affect here. And when you enter into a plea, the key factors is that you understand where it's clear. We're not giving you here's kind of what you're getting. So you need to know what you're getting.
I understand it. That's a lot of points.
Pardon? The score sheet that the state filed here is roughly 43 points.
Right.
And that's where I told her my anticipation is because the way the score sheet works in the state of correcting, it's a different county with a different case, so the score sheet would not include these as primary offenses. These at best would be considered prior history, which you and I discussed.
Right. That's my
That would be correct, Your Honor. The score sheet would flip for Escambia County. The primary offenses would be that VOP offense, and then these offenses, rather than counting higher as an offense that is pending, would count lower as a prior record offense.
And if I can, Your Honor, borrow a phrase from Judge Brown, I tell clients that he usually will say, you may not like the plea agreement, but you don't think it's in your best interest is what he'll come up with in situations like this.
I'm good.
You're good?
I'm good. I'm ready to go to Escambia County.
Pardon?
I'm ready to go to Escambia County. Get it over with.
Very good. Based upon that clear testimony, the court will accept your plea agreement.
Okay.
There'll be an adjudication of guilt on all the charges. You'll get credit for time served. The fees and costs that are contained in the plea agreement will be payable over the next 24 months, and if not, it'll be required. Okay? Franklin? Who on the state is handling Dallas Guerrero?
That would be me, Your Honor. I've been in contact with Mr. Garrett. I believe he was in Walton County this morning. He is rushing over here.
Okay, I'm fine. I'm fine with as long as we did get a couple of lawyers that indicated that Walton County always gets a preference. So.
And I believe Mr. Madden may cover for him, Your Honor.
Oh, really? Okay.
Mr. Garrett.
You want to cover him? Okay, we'll do it after this case. Okay.
You know, this is Mr. DeJean Franklin before the court. He has actually signed the paperwork for the PTI. Ms. Sandler is signing it as well. As part of the PTI, it specifically states that his bonds will be converted to an ROR bond, allowing him to be released. I've explained to him immediately upon his release, he needs to go to parole and probation to check in. I've explained to him, he's let me know there may be a delay on that being released, and I told him as soon as he gets out, he needs to go straight to parole and probation to sign the PTI paperwork. If we can have the court just modify the bonds, he's being currently held on to ROR, and then I'm going to give this to probation to have for Ms. Barras.
State?
That is the state's agreement, Your Honor.
You're okay with the bond being reduced to an ROR?
Yes, Your Honor. He has no prior criminal history. This is his first offense. The state would take no action on the FDA.
Do we need, I'll make an oral order to lower the bond to an ROR. Do we need to paper that some way?
I think if the court just says it can be released on the court minutes, that's enough for the jail.
Okay, if the court minutes would reflect that his bond is being reduced to an ROR?
On the stipulate, and then you limited it.
That's fine.
Yes, Your Honor.
Okay.
And if we could do a control date of, let's say, April the 10th for Mr. Franklin.
Okay, very good.
Thanks.
Yes, we'll do Guerrero, which is out of custody.
Yes.
The court understands when you guys have conflicts with other courts, so you don't have to feel like we're going to get mad because you're somewhere else and you got to be particularly.
I appreciate that, Your Honor.
You haven't figured out by location yet.
The space between the counties is not making things easy. There's no quick way to defeat an actual whole beach, unfortunately.
And it's easier to get to Creston.
Yes.
Quite a bit. You want to go ahead and announce?
Yes, Your Honor. So John Madden filling in, or covering for Chris Garrett on Dallas Guerrero. This is 21 CF 1430. It's my understanding that the charges will be dismissed upon payment of court costs and restitution. I think the clerk is not isn't reflecting the payment, so we would ask for it to be set on either March 21st or April 11th for status.
it confused me just a little bit. It's not being, so you think it's been paid, but it's just not being reflected yet?
Your Honor, Mr. Garrett contacted me and let me know that his client, Mr. Guerrero, mailed checks to Mr. Garrett's office for him to pay through trust. So Mr. Garrett will be making those payments.
Okay.
I believe if we set it for 4/11, just to be on the safe side, make sure everything goes through the clerk's website, the state will be able to file a null process before then, and it will fall off the docket.
Very good. So we'll just have a control date for 4/11.
I will let Mr. Garrett know, Your Honor.
Okay.
Just so you know, it's a $500, no, I'm sorry. Yes, $500 in restitution and $515 in court costs. I've got a total of $515 on the record right now.
I will
You might just pass that on to Mr. Garrett.
I will do that, Your Honor.
I just want to make sure we have it right on our end.
And Madam Clerk, that's 515 court costs, 500 restitution.
Yes, ma'am.
Okay. If there's any disagreement, we'll probably deal with it on 4/11. Okay.
And now I will,
Good? You're
now I
good?
will be myself.
Good. Oh, okay.
On Jamel Ifat, who is present and approaching.
Okay.
We're here on a violation of probation. Your Honor, we have reached a plea agreement with the state, if I may approach.
You may. You may now.
Your Honor, today Mr. Ifat is going to be admitting to the violations. In exchange for that, the negotiated offer is to maintain his withhold. He's already on supervision. He's going to be reinstated to supervision, with the first 12 months of that being community control. Once those 12 months are over, he will convert back to normal state probation for the remainder of his supervision term. He's going to complete a substance abuse evaluation within 30 days and begin any recommended treatment within 90 days. He's going to show proof of employment, enrollment in school, or submit 5 job applications per week. And there's going to be a $100 violation probation fee.
Just want to have one clarification.
Yes, sir.
Well structured. I appreciate you typing it out. The way it reads in here, and I don't think this is what it means to read. It says, complete a substance abuse evaluation within 30 days and begin recommended treatment in 90. Is he completing his requirements when he begins treatment, or does he have to complete treatment?
He has to
begin and complete.
Yes, Your
Begin in 90 days and complete.
Yes, Your Honor.
I
Yes.
thought that's what it was, but it doesn't say that. I don't want
No,
to.
that's
I
the
want
intention.
him to understand what his requirements are, and I don't want to come back. I assume the states.
That's fine.
Okay. So, yeah, you have to start it. You can put it in. You have to start it in 90 days, and you have the term of the probation to complete it.
Yes.
Okay. So would you raise your right hand? Let me swear you in. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I swear.
Okay. So you heard your attorney. Put your hand down. Just want to make sure you understand your plea and your plea agreement, and that you're entering into it freely and voluntarily. So you heard your attorney state the terms of the plea agreement, and that those same terms are contained in the written plea agreement. I'm going to look on the back. I assume you've signed, which you've signed. If you may, first of all, I want to make sure you understand. Have you gone over the terms of this with your attorney?
Yes, I have.
And this is what you're agreeing to? You're in agreement?
Yes.
And you understand that by entering into this plea agreement here today, you're waiving the right to go to a trial and to contest all this. This will be a final resolution of this violation of probation. Do you understand that?
I understand.
Okay. Is the state in agreement?
Yes, Your Honor, this is the state's agreement.
And importantly, on this, you got some valuable terms of this. You're going to maintain a withhold. That's good for you as far as cleaning up your record going forward. You're going to reinstate probation. But this includes 12 months of community control. Okay, do you understand what community control is?
Yes, I do.
I don't like that term, community control. I like the slang term, house arrest. But that's really what it is, right? You got to stay at the house. Can't be going out. It's not, it's not like you don't have curfew anymore. You got to stay at the house unless you're going to a job or going to one of your, something that's been approved. Do you understand that?
Yeah.
The reason why I'm going over that with you, because I want you to understand that a lot of people, oh, good, got this done, move on. This ain't the move on part. This is the get started part. You got a real opportunity to get this behind you. You got to put some effort into this thing. You got to take your stuff seriously. You got to show up on time on a regular basis. Not rocket science. Got to show up. Okay, you with it? You in agreement with all this?
I agree.
Okay. Very good. Based upon that testimony, then the court will accept your plea agreement, maintain the withhold of adjudication, reinstate probation with the next 12 months being on community control. After those 12 months, the remainder of the probation will be basically standard state probation. Importantly, you've got to complete a substance abuse evaluation in 30 days, begin treatment in 90 days, and then finish during the term of the probation. And then the employment, you need to follow up, you'll be enrolled in school. Or fortunately, we've got plenty of jobs around these days if you're not in school. Okay, any questions? Thank you very much.
And Your Honor, the state will be providing a copy of the score sheet to the court, and it should reflect 31 points, so he does not score.
Okay.
Yes, Your Honor, it will be 31.1 in admin. It's printing downstairs. So I'm gonna let Mr. Madden look at it before he leaves, and then that way I can give it to once I have a break, I can go grab it and give it to the court.
Okay.
Just want Mr. Madden to know what I'm giving to the court, obviously, before I give
Very
it to
good.
him.
Sounds good to me.
Okay, thank you very much.
Thank you, Your Honor.
Michael Jenkins.
Yes, Your Honor. Mr. Jenkins was noticed for a Nelson hearing. If the court will allow, I'd like to stay at the table because I have access to my computer if I need to pull up a note or something.
Well, here's the problem. I understand that this was set for a Nelson hearing.
Yes, sir.
But I don't find that any motion for a Nelson hearing has been filed.
Mr. Jenkins had someone drop off a copy of it to my office yesterday. I can give the court a copy of it.
Has it been filed?
Yes, sir.
It just hasn't shown up on the clerk's website.
May I approach, John?
Sure.
If you look at documentary, number 74 in 2308 is when this correspondence done by TCA.
And, Your Honor, just before we get started on the hearing, I want to make sure the record's clear. Mr. Jenkins understands that by proceeding in the Nelson hearing, he is waiving his right to attorney-client privilege. So anything that would normally be privileged as far as communication concerned, he has understanding he's waiving that right because he's claiming that I'm ineffective. I have the right to disclose certain conversations and the like on the record at this point.
Well, I just have a procedural issue that this.
Yes, Sean.
Don't know why this was, well. I haven't had a chance to read this. You want me to read this? We got one or two ways to proceed here today. I can just let you, I'm going to put you under oath. You can testify whatever you want. I'm gonna ask you a few questions about why you think your attorney is not operating the way you believe he should. But I haven't read this. This is 3-page, single space. Are you relying on this?
I can guess let's go through that.
I'm sorry?
I said we can continue and let you go through that, and when you get a chance to read it, you know.
Yeah.
And the only reason we said it when we did, Your Honor, is because once he makes the request for Nelson hearing, we have to stop communication with Mr. Jenkins. So I can't communicate with him. I can't do anything until we get a ruling on the Nelson hearing, which is why we always try to set it for the next available court date.
Mm-hmm. Well, I don't mind setting it for the next one, but this seems like it's going to be more than 5-10-minute hearing.
I wouldn't. When I said it, we didn't have that, Your Honor. However the court wants to do it, I'm okay coming back this afternoon if the court wants to try and read it. I just want to make sure the court's aware I can't communicate until the court makes a ruling on
Sure,
this.
I understand. And I appreciate that. Here's what I'm going to do. I'm going to set this for this afternoon because it's going to take a little time. I've got 4 substantial hearings.
Yes, sir.
Plus all the arraignments.
Yes, sir.
I'm not sure we can get it in.
Yes, sir.
But if we can't get it in, we'll get it in. This will be at the end.
Yes, sir.
We can get it in. If not, we'll do it at the very next hearing we can. Okay. So we'll come back, we'll bring it back at 2:30.
Take care.
And I'll read it over the lunch hour, so at least I'll be ready for that.
Take care.
Appreciate that. Okay. Do you want to, why don't we take a short break after this one, just so we can.
Yeah, this is Mr. Richard Lane. We had left him as a status. The state and I were discussing the motion that I had filed, and after speaking to the state, I'm going to let Mr. Rogers address it, but it sounds like we'll need to set this for an evidentiary hearing sometime in April.
That's accurate, Judge. What was going on is Mr. Gates and I were discussing whether ground 1 of his motion requires that it be sworn, as a C4 motion would typically. After doing some research, I think we both come to the agreement that there is no way that Mr. Lane could properly swear to the motion, so it should just be a 2B motion, which requires an evidentiary hearing, which of course we're asking the court to set today.
How long of a hearing are we looking at?
An hour? At best, I think. An hour max. And part of the issue here is that the hearing may simply be the admission of deposition transcripts and police reports based upon stipulation of the parties. It could also potentially involve calling witnesses, but at this point, rather, that's up in the air. But I would say an hour max.
Okay.
There is one additional thing I'd like to put on the record.
Sure.
In doing my research related to the case, I came across case law that indicates that if Mr. Lane does go forward on his motion seeking to challenge certain charges that are contained in the information based upon the statute of limitations, that essentially precludes him from asking the court to present lesser included offenses to a jury if those would have been barred by the statute of limitations. So the reason that's important is that count 1 as currently charged is a life felony. So essentially, if Mr. Lane does go forward on this motion, he's essentially waiving his ability to request lesser included offenses should this case go to trial. So I just wanted to put that out there and make sure that it was on the record. The other thing I need to address.
Let's deal with that.
Sure.
Yes, Your Honor. And Mr. Lane and I have had a couple of different conversations about that particular issue, and I've explained to him essentially what the state's saying. It's an all or nothing. Either he's guilty as charged in the information, or he's not guilty. He and I have discussed that. I've given him my thoughts and concerns about that. At this time, I think we're still inclined to move forward with the hearing. Obviously, if we decide differently, we can let the court know before we actually have that hearing.
Okay. I'm going to just swear you in just for a second, Mr. Lane. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court the truth, nothing but the truth, so help you God.
I do so.
I just want to acknowledge what's on the court, that you're shaking your head yes, and that you're in agreement with your attorney. You've gone over this issue with your attorney, because it has some real ramifications. Just want to make sure as we proceed, one of the things that's important is that everything's on the table, on clear, where nobody's trying to trick one another, and particularly the defendant has to understand what's happening going forward, so he or she can make decisions. So that's why I'm asking you these questions. Okay, now, what next do you want to?
So the final issue, if we do ultimately go to hearing on this,
what is the motion? It didn't show up on my docket.
So it's a motion to dismiss, Judge.
Okay.
It's based upon statutes of limitations, and there are 3 independent grounds that have been asserted by Mr. Gates in the motion.
Right.
What I want to make the court and Mr. Gates aware of is that should we go to hearing, the state is essentially going to stipulate to grounds 2 and 3. Those grounds are well taken. Essentially, Mr. Gates has argued that if we're not dealing with a life felony in this case, then any other charge is barred by the applicable statute of limitations. He's correct. I don't want to stipulate today because, of course, we've addressed the fact that if Mr. Lane does successfully challenge the statute of limitations issue, he's essentially locking himself in. So I just want to put the court and Mr. Gates on notice so that you all aren't preparing for grounds 2 and 3 in preparation for this hearing.
But ground 1 would go forward.
We do intend to argue ground 1, correct?
Okay. Mr. Gates?
Yes, sir, and that's a conversation I've had with Mr. Lane as well. Essentially, the hearing is for the court to make the legal determination whether or not the charge should be sexual battery with a deadly weapon or sexual battery without a deadly weapon. I'll put it that way. And then depending on the court's determination at that hearing, trial or no trial depending. As far as the burglary charge, he and I discussed that essentially that's gone at this point. The state's told us that it's just a matter of whether we need to have a hearing or what the court rules at that hearing.
So, Madam Clerk, what does our afternoon docket look like on, well, we could look at 21, but probably.
And I've talked with Mr. Lane. I've talked with Mr. Lane. I think the 18th date is the date that he and I discussed.
What does our afternoon look like on April 18th? We're jammed up on that.
Okay, you have 4 cases on April 11th. I try not to go over 5.
Yep, no, I thank you for
There are 4
that.
on April 11th. Do you have anything before April 11th?
I don't know that we would be ready in a week.
Okay. I just didn't know if there was anything maybe on the 28th.
No.
It just, it has the date bolded, it doesn't tell me what it is, just
It's all right. So either possibly, can you be ready by April 11th? If not, we'd have to go to May 9th or May 16th.
Yes, Your Honor, and I think that April 11th will be plenty of time. I know that I've also spoke with the state about a potential resolution as well, so it really is a matter of also having time for the state to potentially work on that as well.
Okay. So we'll continue the motion to dismiss hearing till April 11th, and that'll be at 2:30, so it'll be in the afternoon.
Thank you, Your Honor.
Thank you.
Mr. Catalytic. Yes, sir. Came in, so before we'll have Mr. Catalytic, and then we'll take a mid-morning break. Mr. Catalytic, how are you doing this morning?
Your Honor, I have James Melvin Grimbaugh. Mr. Grimbaugh, sir, come on forward, please. 2023 CF 377, Your Honor. We're here on a motion to amend the no contact order to a known violent contact order. I have an affidavit from the victim inside the court file. She's indicated that she doesn't want to go forward. She's indicated that he does not pose a danger or risk to her, and that she would like the no contact amended to a non-violent contact. And she also The final order, there was a final order dismissing the temporary injunction for protection against domestic violence, and that was in 23 DR 179, and I submitted that to the court as part of Exhibit B.
What's the state's position?
Your Honor, the state is objecting based on the nature of the allegations. To be quite frank, sometimes the job of the state is to protect the victim, even when the victim does not realize that that's in their best interest. This particular offense involves a threat with a deadly weapon and a sexual assault.
Judge, she's here as well to testify if the court needs her to.
Is the state intending to move forward with this case?
The state is intending to move forward right now, Your Honor.
This case not being, if this case, the state's moving forward on this case, I'm not gonna change the no contact at this point.
Very well.
So I'm gonna deny this at this point. That may change along the way, but at this point.
Very well. So we can come back in.
You can.
Very well. Thank you, sir. I think I have an order.
I'm sorry?
I think I have an order as well. It's okay. It's okay, come on.
Okay, let's go ahead and take a morning break, mid-morning. We'll come back in about 10 minutes. All right.
Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
Hi, I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi everybody, this is Alex again from the UPS store. Maybe I can let you in on a little secret. Did you know we're open on Sundays? Yeah, since February, probably one of the best kept secrets in Crestview, we're open on Sundays from 10 until 3 p.m.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
At Powell, Powell & Powell, we are a family of lawyers working together as a team for our clients. For more information, visit us online today at www.powelllawfirm.com.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
For next week.
You got the inmates lined up. Do you have any out tested?
I don't.
I have all the, I think, matters that remain.
You want to figure out tested before we go in?
Whatever the court would prefer.
Let's do that.
Your Honor, can I approach with the score sheet for Ms. Georgina Halsey? Sure. State attorney, had to make some amending to it. It's still 44 points, so there's no need to go on the budget. Very good. Thank you.
Good morning, Your Honor. Ryan Morrow for the record. I'll call first Ms. Sheena Hall. Your Honor, she's not present. It's my understanding she is currently incarcerated at Escambia County Jail. Her father did make the trip out to let us know, but I was made aware.
Well, I'm trying to find out where we're at on your docket.
I'm sorry, Your Honor. This is Sheena Hall, Hall, and all of mine are towards the bottom of the docket.
Gotcha.
You did sign an order to come on like 8 days ago.
Okay. So where did you say she was?
Escambia County is my understanding, Your Honor.
So what do we need to do with that today?
What I typically see is we just let the warrant stand on the bond revocation. They'll put a hold on her, and then once she finishes up with her Escambia matter, she'll be brought here.
I agree.
Okay.
And just for the awareness of the parties, one of the attorneys in Escambia has raised a conflict. I anticipate that she'll be going to RCC, just so everyone knows.
Very good. Thank you.
Thank you, sir. Next, Your Honor, is Mr. Martin Lewis. Ryan Morrow for Mr. Lewis. This is 21 CF 2963 Alpha. He's approaching from the gallery. State has suggested drug court as a potential resolution for this matter, Your Honor. I ask to continue this matter so we can have a proper evaluation done and see if that's something that we can resolve to.
Okay. When do we want to come back?
Your Honor, I also wanted to mention that I'm going to be out of town from the 14th of April till the 19th of April. So I would ask probably whatever date the court has after the 19th of April.
We've got one April 11th.
I will take April 11th. I'm not certain on the turnaround for a drug court evaluation, but I think that's probably enough time.
Okay. So we'll continue to 4/11 for drug court eval. Okay, very good.
Give me a call.
Okay.
Next, Your Honor, is Mr. Robert Davis. Ryan Morrow for Mr. Davis. This is 16 CF 2807.
And Your Honor, in Mr. Davis's case, I received communication from Mr. Morrow that the defendant had completed the treatment you said and he paid the financials, correct? Can I just have probation confirm that? I'm sorry I didn't get to that earlier, Officer Dewey.
Financials are taken care of. It's just waiting to disperse for the court costs. Otherwise, his conditions are.
The treatment is
Yes.
Okay. Your Honor, at this point, the state will withdraw this violation and terminate the defendant from probation, as all conditions have been met.
So we're terminating probation as well?
Yes, Your Honor, if we're just waiting for the disbursement to come through, if he's paid it, we're just waiting on it, I think we're all good.
Yeah, the money's sitting there, it's just waiting to disperse.
I think we're all good, Judge. The state would move to withdraw and terminate.
Very good. The court will grant that. Good luck for that.
Appreciate it.
Thank you.
Next, Your Honor, is Mr. Kyle Bird. Mr. Bird has 3 matters before the court. They're all VOP. It's 18 CF 2342, 18 CF 2343, and 19 CF 2696.
And Your Honor, at this time, what is remaining for Mr. Bird, I believe, is financial, and the department's recommendation was to convert the remaining financials to a civil lien. At this time, we would ask that the court order the financials to a civil lien. And then after the court orders that, the state intends to withdraw and terminate Mr. Bird.
We have no objection to any of that, Your Honor. That was our understanding.
The court will order the financials to collections, and the state is withdrawing the VOP?
Yes, Your Honor.
Very good.
You're done. The rest of mine are, yes, Your Honor.
Okay.
Dane Solomon.
Travis case on behalf of Mr. Solomon. He should be number 34 on the docket, Your Honor.
Very good. Thank you.
Your Honor, Mr. Sullivan had court yesterday on the misdemeanors. It sounds like he actually got those resolved yesterday with a probation sentence. Those were the subject of this violation. I know that he does score. I don't know if the state wants to take a look at it and see.
You mind if we continue up a little bit so we can have a chance to actually take a closer look? He does score in this case, Your Honor. This is a case where the state is essentially balancing a score against mental health concerns, Mr. Sullivan's history. I would like it if we had just a little bit of time to take a harder look at that time.
We can bring back next Tuesday, Your Honor. I think we'll have a resolution.
We'll continue to 321.
Your Honor.
Thank you.
Sam Bergant.
Sam. I don't know where that E came from.
Yeah, I don't know where this came from.
Charles Russell, Public Defender's Office for Mr. Medina. Judges, Mr. Bergant. Case number is 22 CF 2295. Mr. Bergant also has a case on this afternoon's docket. It should be page 2 of that docket. It's a felony plea day on case number 23 CF 289. I have a proposed agreement if I just have a moment, Judge.
Okay.
Judge, may I approach? Yes, sir. And I do have a couple of issues, Judge, but on 22 CF 2295, which is the violation of probation, he's going to admit the violation of probation. It's going to be revoke and terminate, 6 months county jail, concurrent, credit for all time served, $100 VOP fee, $100 PD fee, D6 any remaining DUI requirements, and he's going to have 120 days after he's released from jail to pay any money owed, or it would go to a lien. On 23 CF 289, he's going to plead no contest to those charges, an adjudication of guilt on the misdemeanor possession of paraphernalia, but a withhold adjudication on the felony. He's going to be placed on 9 months probation on the felony with a special condition that he serve 9 months in the county jail concurrent. He's going to get credit for any time served. The felony probation will automatically terminate upon his release. We would ask to waive cost of supervision in the felony probation, and he would pay $615 in court costs, $150 public defender fee, and any monies on that case, he would also have 120 days after release from jail to pay any money owed, or it would go to a lien. The two issues that I have are that in 22 CF 2295, which is the violation of probation, no affidavit of violation has been filed. I think what happened is that the judge at first appearance issued an order commanding arrest because of the new case, when he came in on the new case. So I don't know if that complicates things, but it's going to be a revoke in term, so I don't know if that causes an issue for either the clerk or probation.
What the clerk would do is just open the case back up based on your order today, and then turn around and close it.
Okay. That'll work. Any problem from probation standpoint?
I didn't catch that, sir.
Any problem from probation standpoint? Because there's no VOP affidavit in the violation of probation, but we're just going to revoke and terminate today. That doesn't cause a problem with y'all, does it?
No.
Okay. And then my second issue is that on the score sheet, if you look at the second page, the state is assessing 12 points for a new felony conviction. The case that he was on probation for, 22 CF 2295, he was on probation for misdemeanors. It was in felony court, but it's not going to make a difference since we've worked out a plea agreement.
And he does score any time?
He doesn't, yes, sir. He doesn't score anyway.
Okay. I'm a little bit, I was following you, but doesn't translate exactly.
Okay.
Because you actually don't differentiate between the two cases on the plea agreement. So the VOP is revoke and terminate probation, and then 6 months county jail.
Correct, Judge.
Concurrent. With credit for time served.
Yes, sir.
And then it says new term of 9 months probation on the felony. Is that the new charge?
Correct, Judge. On the new case, 23 CF 289, it would be, and this is to preserve or withhold adjudication. Since it's going to be withhold adjudication on the felony, it's going to put him on 9 months probation with a special condition of due 9 months in the county jail, concurrent, credit for all time served.
That's concurrent with the 6 months?
Correct, Judge. And then the probation would automatically terminate upon release from jail.
Okay. I think I understand. That's the state's agreement?
That is the state's agreement, Your Honor.
Okay. Mr. Burgown, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, Your Honor.
Okay. You heard your attorney's explanation, and I see you signed the actual written plea and sentencing agreement. It's a little bit confusing.
Yes, sir.
Two things. I want to make sure that you understand what you're doing, and I want you to make sure that you're doing it freely and voluntarily. That's the whole purpose of my questions, okay? So, you heard what he said, so it's, bottom line is 6 months county jail on the violations of probation, 9 months in county jail on the new law charges. They'll be served concurrently. You will get credit for time served on both of those. They're separate. It's a little tricky. Can't tell you precisely what the credit for time served, but you will get credit for time served on each one of those. Okay? That's the core of this. Then you got the fees and costs and et cetera, where you've got to pay within 120 days or money would go to judgment, would be waive the cost of supervision on the felony. So I assume he's got some credit for time served on the new law charges.
Yes, sir.
So if he's got 9 months on the special condition in the county jail and 9 months of probation, the effect of that would be that there's going to be 9 months minus the credit for time served, which would be less time than the 9 months of probation. So he would get some period of time where he would be on probation based upon my read of this.
No, sir, because if you read where it says that the felony probation would automatically terminate upon release, so as soon as he gets out of jail, probation
That's why
ends.
that was put in there, Judge.
That was the intention of the parties, Judge.
Okay. So the reason why it's not clear is because it's kind of a complicated plea agreement because they're trying to maintain your withhold of adjudication, which is a benefit to you, okay, and going forward with your record, etc. Okay, so that's why some of this complication is basically your attorney's trying to work a good deal for you. Okay, so with that explanation, is that your understanding what the plea agreement is? Do you have any questions?
I have one question, Your Honor.
Okay.
And that is, so without the adjudication being withheld, I would lose my right to vote. Is that correct?
If you were adjudicated, yes.
Yeah,
You
that's
would
right.
lose
But
your right.
with the adjudication.
Are you asking conversely with the withhold?
Yes, sir. Am I still going to be allowed to vote?
Yes.
Okay, that's all I needed to ask.
Okay.
Thank you.
Very good. It's good question. Good question. Okay. So you understand that by entering this plea agreement here today, you're waiving the right to you contest all this, go to a trial. This will be a final adjudication of both of these cases. Do you understand that?
Yes, sir.
You believe it's in your best interest to do that?
Yes, sir.
Been able to ask all the questions you need to of your attorney to make sure you understand what's going on here?
Yeah. Yes, sir. Yes, Your Honor.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement. And the court on the violations of probation, which is 22 CF 2295, court will revoke and terminate probation, sentence you to 6 months in the county jail. You'll get credit for all time served. In the new law charges, you'll be sentenced to 9 months of probation with a special condition of 9 months concurrent, Okloosa County Jail, with credit for time served on that as well. And then the felony probation would automatically terminate upon release. Fees and costs, you got 120 days to pay. If not, it'll go to judgment and waive the cost of supervision. Okay? Any questions?
So the lien, the cost after 120 days, what?
After 120 days after you get out of jail, you got to pay the fees and costs, or it would go to collection.
Okay, and I understand that now. Being indigent, I was also told that the county clerk allows community service, possibly as hours that count towards being indigent and homeless. I'm able to do community service to work off the funds for the court costs.
State?
I don't know how that's set up, Judge, but if the clerk can set that up, I don't object to that. I don't know how it gets set up, to be truly honest with the court. I think that
Can
might be something
probation
needs
weigh
to-
in on that? Do you understand the question?
Whether or not he can complete community service work in lieu of his court costs.
Can he pay for the fees and costs by community service hours?
Yes, sir, he can, but it is not at the statutory rate of $10 per hour. I don't know what the statutory rate is off the top of my head. I believe it's the minimum wage.
Okay. And does that go for the public defender fees as well as the VOP and the court costs?
I do not believe so, sir.
That's what I understood, that they can't do it for the public defender fee, so you probably got the best deal you got to get the legal defense for $250, so that's a good deal. You'll have to come up with that, but the rest of that can be done. Do we need to put it in here? Or is it something that can be worked out?
I can add it if you want me to, Judge.
Okay. Sure.
Pardon me, Your Honor.
Yes,
It
sir.
appears that he is on JCS, not felony probation. So he's on county probation and not with us.
Okay.
I don't know whether or not their community service work operates the same as ours.
Okay, so you're taking that back as far as whether that can be done. Just put on there if it's.
Your Honor, because you're terminating the supervision on the case that is monitored by JCS, it would then be up to the clerk. You've given him 120 days for judgment. At the end of that 120, we have in our system a report that prints, and if we don't see money paid or community service done, then we send it to a judgment. We check for that. When it's left on the clerk to get costs for community service.
But he's trying to figure out if he can work it off through community service hours.
Well, yes, sir. And I'll put it in the system that way. And at the end of 120 days after he's released, after his 9 months credit for time served,
Right.
I'll put a compliance record in. And then we have someone that actually gets a report on that, and they'll check to see if the community service work was done or if there was any money paid. And anything else that you need to do.
Yeah, that was glad.
So that is 9 months.
Okay.
And then 120 days after that.
Okay.
I'll make sure you get
Bridges? Charles Russell, Public Defender's Office for Deshaun Bridges. This is case number 21 CF 502. I'm covering for Mr. Medina. Judge, if I could have a moment. Judge, you have a plea agreement if I may approach, Judge?
Thank you. Could you announce, please?
Yes, sir. Mr. Bridges is before the court on a violation of probation. They're both misdemeanor counts that he pled to originally. In exchange for an admission of the violation of probation, it's going to be an adjudication of guilt on both counts, revoke and terminate his probation. He'd be sentenced to 30 days county jail, concurrent credit for time served on both counts. he would pay a $50 cost of prosecution, a $100 public defender fee. The state will not pursue the failure to appear, and he will get 180 days after his release to pay any money owed, or it would go to judgment.
Very good. Mr. Bridges, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney, put your hand up. You heard your attorney state the terms of your plea agreement. I see those same terms are contained in your written plea agreement that I see you've signed.
Yes, sir.
Is that your understanding of
Yes,
the plea agreement?
Yes, sir.
And have you gone over this plea agreement in detail with
Yes,
your
sir.
attorney to make sure you understand all the legal ins and outs?
Yes, sir.
Understand, big deal is you're waiving the right to go to a trial.
Yes, sir.
This is the final adjudication of your case.
Yes, sir.
You believe that's in your best interest?
Yes, sir.
Do you have any further questions regarding this plea agreement?
No, sir.
Okay. Based upon that testimony, the court will accept your plea, the admission of violation. The court will adjudicate you guilty, revoke and terminate probation. You'll be sentenced to 30 days in the Okloosa County Jail. For each of the 2 violations, they'll be served at the same time, concurrent. Okay? You'll get credit for all time served. Fees and costs, you've got 180 days to pay after release or it goes to judgment. And the state agrees that they will not file any charges on the failure to appear, correct?
That's correct.
Okay, very good. Any questions?
Yes, sir. I have one question.
Yes, sir.
For this failure to appear, they gave me a traffic ticket, which is the reason why I violated my probation, which was a driver's license, not having a driver's license. I have a driver's license. They never gave me a court date for this FTA. They told me they would run these 2 concurrent, but they're not running it concurrent. And I have a driver's license and everything. I'm in here on a traffic ticket for driving without a license, but I have a license. So I didn't understand why they didn't run it all concurrent.
I think what he's referring to, Judge, is he has a separate criminal traffic case, and I explained to him that they aren't together. He probably needs to deal with that case and go contact the clerk's office about that.
You would think that we're all in the same county and we're all operating out of the same courthouse and the same clerk, but unfortunately sometimes these things get put in their own categories. Actually, a different judge handles traffic. I don't ever handle traffic, thank goodness.
All right.
So I can't kind of traipse on their domain, so I can't do it.
Right,
Sometimes they run them together, but usually they don't.
Okay, I understand that.
Okay.
Thank you.
Sure.
Charles Russell, Public Defender's Office, covering for Steve Medina, Attorney of Record. Judge, this is Damon Pittman. Case number is 23 CF 200, and Mr. Pittman is before the court on a motion for bond reduction. Mr. Pittman can testify if you want him to, but he's basically going to state the same facts that are in the motion if the court just wants to look at that.
I've reviewed the motion.
Okay.
If the defendant wishes to add anything, you can.
Just briefly, Judge, if you want to swear in.
Would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You may.
Okay. And I see on the paper they didn't. I see it got me with the defendants finished 12th grade. I'm also adding myself to school to get my diploma.
I'm not understanding you. Slow down.
I'm sorry. I said I've also enrolled myself in school to get my diploma.
Okay.
And I have my own business, landscape business called Treetop. And I'm also in commercial schooling to get my CDLs. And my six kids they have one here, 5 of them, their mother died 3 years ago. So I'm a single father of 5 of them. Me and my new wife just had a newborn. But my other 5, I have on my own. My mother died December 5th of 2020. I see they didn't, me and Mr. Klein's talking about it, but I see they didn't put it in there.
And you have custody of all 5 of your children?
Yes, sir.
Where are they now?
They were with my grandmother, but she just passed last week. They just had a funeral Saturday. My furlough was denied to go to the funeral last Saturday just passed. So they were with my grandmother, but my mother has them now. Because my new wife, I mean, she can't handle all 6 of them by herself, especially with her trying to find a new job and all that. And then she just kept on joining nursing school, so my mother has it right now as we speak.
What's the state's position?
Your Honor, the state does object to a reduction in bond. The defendant does score 51.2 months by the score sheet that I have prepared for this case, Your Honor. On his criminal, he's charged with armed burglary of, I believe this was a structure if I'm not mistaken, Your Honor. He has 1 prior burglary of an unoccupied structure or conveyance in his past. He has 2 prior possession of a controlled substance, which is the second and third count of the information that's been charged against him in this case, Your Honor. So based on the fact that he does have other history on his score sheet, my score sheet reflects 17.5 points in prior history. That includes those priors that I was just talking about. Given that he has a history with same or similar offenses, Your Honor, the state believes that the bond that's as it's set now is appropriate.
Mr. Russell, you want to make any further arguments?
No further argument, Your Honor.
You see, they had talked to the traffic authority, but they still kept it. They still kept it at. They never dropped the ball.
What he's bringing up, Judge, is that one of the counts, he was charged with a trafficking amount, and the bond was set at $15,000. But that's included in the total of $41,000 that we quoted in our bond motion anyway. So.
Okay, it's been dropped to a possession.
Correct.
The court will reduce the bond by 50%, not reducing it to a signature bond.
Okay.
So each of the bonds will be reduced by 50%. So it's 10, 7,500, 2,500, and 500.
Okay, I only have 3 counts on here.
There's a 4th count that was, he got a bond on. It was like $1,000.
And it looks like they didn't file on that, Judge. So it's just the first 3.
Okay, so
This
then
is a
it'll
3.
only be a total of 20,000. It'll be 10, 2,500 for count 2, and then 7,500 for count 3. Thank you, Madam.
Okay. And Judge, he's set for pretrial on April 10th, so I guess we need to change that to April 12th?
Yes.
Since he's, well, if he gets out.
Yeah, well, we can always, we'll have him come back on the 12th, and if he gets out, we'll move him.
Okay, great. Thank you, Judge.
Ed Cheney.
Ryan Morrow from Mr. Cheney, Your Honor. This is 21 CF 27. Your Honor, this is going to be a negotiated plea on the VOP in 21 CF 27. The agreement between the defendant and the state is they'll get terminate and 5 months in the county jail with credit for all time served. 23. May I approach?
You may. Thank you. Mr. Cheney, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Now, this says 5 months in the county jail for which of the 3 charges? Don't we have to do each of the 3 charges?
Oh, I'm sorry, Your Honor, that's concurrent on all counts.
Each of the 3 counts?
Correct.
Okay. Got to make this precise. Come get it. Got to get this precise because it's going to be the court record.
He was previously adjudicated.
Okay. I'm looking.
I've interlineated just above that passage, Your Honor.
Okay.
May I approach?
Did I swear you in, Mr. Cheney? Let me swear you in. Did I swear you in already?
Yes, sir.
I'm doing it too much this morning.
Yes, sir.
Okay. So you heard your attorney state the terms of the probation, of the plea agreement. So we're going to revoke and terminate probation. So you're finished with that.
Yes, sir.
You're going to serve 5 months in the county jail on each of the 3 charges.
Yes, sir.
And they'll run concurrent. I mean, they'll run at the same time.
Yes, sir.
You will get all credit for all time served.
Yes, sir.
And then you've got 6 months after you're released to pay the fees and costs.
Yes, sir.
Then it'll go to collections. Is that your understanding what the agreement is?
Yes, sir.
You understand that by entering this plea agreement, which I see you've signed,
Yes, sir.
this is a final resolution of your case. You're waiving the right to go to a trial, confront witnesses, etc.
Yes, sir.
You believe this is in your best interest to enter into this, and you've had all your legal questions answered?
Yes, sir.
Okay. Very good. The court will accept your plea and sentence you as stated in the agreement. Thank you very much.
And Your Honor, I do have a score sheet for the court. The total sentence points are gonna reflect 32.5. I have it up on my computer if I can show Mr. Morrow that, and then I will go print it out when we take a break and give it to the court, if that's okay with Mr. Morrow.
And she has advised that represents the downward departure based on negotiated plea.
So
The total sentence points are 32.5.
Oh, I'm sorry.
32 points, not 32 points.
I misunderstood.
That's all right. Very good. Randy.
Bobby Collier.
Bobby Collier.
Your Honor, I'm just going to make sure that it's clear on the other 2 counts before I approach, but this is going to be a negotiated plea. Revoke and terminate 1129 in the county jail. I'm just going to add in for clarity on the other 2 counts.
Thank you.
Yes, sir. On misdemeanors.
Are you sure the clerk is saying 2 of the counts had timed out and they're not on the VOP? We just need to clarify that.
In this particular case or the last case?
This case.
Well, then we'll address them at all then, Your Honor.
Okay. With the state, do you understand what the clerk has raised?
I heard Your Honor, I'm just looking at it really quickly.
If they've timed out, they've already been resolved. You don't have to address it here. Just wouldn't even be mentioned because you.
Madam Clerk, you're talking about the misdemeanor counts, is that what you're
Yes, ma'am.
addressing?
They're on the affidavit filed on October 20th.
Your Honor, that's obviously fine. It can be 11 months, 29 days on count 1 only. That's
Okay. Thank you, Madam Clerk.
included in the Blue Line score sheet as well, man.
You may.
There is a violation of community control, not probation. Is that in fact true? I just saw it. There was 6 months community control followed by 4 years of probation.
So there's community control of probation, and it's the same thing.
Yes, Your Honor, I didn't know if I
Revoking
needed
and
a different
terminating
form.
Probation. It actually is a community control plea agreement. It actually says that on
Okay.
here. Okay, we just want to make sure it's clear.
Yes, sir.
Thank you, Madam Clerk. So, Mr. Collier, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you were originally charged with 3 counts. One was possession of a controlled substance, that's a felony. The other 2 were misdemeanors.
Yes, sir.
You've already timed out on those misdemeanors
Yes,
because
sir.
they're a year. So we're not dealing with those. Those have been concluded.
Okay.
So as to the possession of a controlled substance, there was a violation of community control, and the plea agreement is to, I assume there's a previous adjudication? of
He
guilt?
was adjudicated on the underlying, Your Honor, is what my file reflects.
So simply revoke and terminate, finish the probation, done. 1129 in the county jail, you get credit for all time served. And then fees and costs that you've got 6 months after you're released to pay.
Your Honor, may I address one other thing?
Sure.
Your Honor, the state's also mentioned a request for the transport fees. I believe it's about $89. My client has no problem. I'll add that into the plea if it need be.
$89.45, Your Honor, and I apologize to Mr. Morrow that I just caught that.
That's all right, well.
And Your Honor, I also do need to print out the score sheet in this case, and just so the court's aware, this is going to be a downward departure based on a negotiated plea. His lowest permissible sentence is 12.9 months, so it's a downward departure by just a few months.
Okay.
A few days.
So, Mr. Collier, I see you've signed the plea and sentencing agreement. You heard your attorney state the terms, basically 1129, credit for time served.
Yes, sir.
Is that your understanding with the plea agreement?
Yes, sir.
And have you had a chance to make sure you've gone over this agreement in detail? Have you read through it?
Yes, sir.
It's got a bunch of other stuff in here too. And you made sure you had all your legal questions answered. Do you understand this? You're waiving the right to go to a trial, you're waiving the right to confront witnesses.
Yes, sir.
You believe this is in your best interest to
Yes,
do
sir.
this? Okay. Based upon that testimony, the court will accept your plea. There's a previous adjudication of guilt. The court will revoke and terminate probation. Sentence you to 11 months, 29 days in the county jail. You will get credit for all time served. There's a cost of transportation and fees and costs. You'll have 6 months to pay, and it goes to collection.
Okay, thank you.
Okay? Thank you.
Daniel, 14.
And what's the other one?
Cody Irish.
Cody Irish is an add-on. Well, the ones that she had were 2 things, but we did come back and one of them back. That's fine.
Ryan Morrow for Mr. Forjone. This is 20 CF 580 Alpha. The case is DOP. I have we're getting a signature off of my client, and then I will have a signed plea agreement and a score sheet, Your Honor. And essentially, the agreement is just asking the court to revoke and terminate a probation and impose a previous suspended sentence that was offered.
Okay.
And I think, based on the score, it
What's the
represents
suspended sentence?
1129.
You-
I think based on the score, it represents a slight downward departure, and I don't know because of the suspended sentences.
Is this yours?
Yes, Judge, this,
The downward departure is based upon what?
which is an uncoerced plea verdict.
Okay, very good. So, Mr. Forgione, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. It's pretty straightforward. Revoke and terminate probation, 1129. You get credit for all time served. Fees and costs got to pay within 6 months of getting out, or it goes to collections. Is that your understanding of what the plea agreement is?
Yes, sir.
And I see you've signed the written plea agreement as well. Have you gone over this with your attorney? Make sure you had all your legal questions answered about this?
Yes, sir.
Because you're waiving some valuable rights. Just want to make sure you're doing it knowingly.
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea, revoke and terminate probation, sentence you to 11 months, 29 days in the county jail. You will get credit for all time served. Fees and costs are to be paid within 60 days of release, or it goes to collection.
Thank you, Your Honor.
Thank you.
Alfredo Morales. Morales.
Ryan Morrow for Mr. Morales, Your Honor. This is 19 CF 3278 Alpha. The case is VOP. And this is going to be a negotiated plea on the VOP, Your Honor, for 9 months in the county jail with credit for time served. May I approach?
You may. Thank you. Mr. Morales, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, you heard your attorney, you can put your hand down. You heard your attorney state the terms of the plea agreement.
Yeah.
And that is that revoke and terminate probation, 9 months in the county jail, you get credit for all time served, plus some fees and costs. Is that your understanding of what the plea agreement is?
Yeah.
Yes? And I see you signed the written plea agreement. Have you gone over this in detail with your attorney? Make sure you had all your questions answered?
Okay.
If you have any questions now?
Yeah.
Go ahead, ask your attorney, and then he can ask me. Okay, did you get all your questions answered?
Yes,
So, just want to make sure you understand what you're doing here, and that you're entering into this freely and voluntarily. So you understand this will be a final resolution of this violation?
Yes,
And,
sir.
you know, once you serve this, you put behind you no further probation at this point.
Yes, sir.
Okay, do you understand that?
Yeah.
Okay, very good. Based upon that, the court will accept your plea, revoke and terminate, sentence you to 9 months in county jail, credit for time served. Fees and costs payable in 6 months after your release, or it goes to collection. Okay? Thank you.
Cody Irish.
You admitted? No.
He is, Your Honor. Ryan Morrow for Mr. Irish, Your Honor. This is going to be a negotiated plea on the VOP and 22 CF 1631 Alpha. And once I have a signature off my client, Your Honor, I'll have a signed plea agreement and a score sheet.
Very good.
May I approach?
You may. Thank you. Could you announce the plea?
Yes, Your Honor, that would be revoke and terminate probation, adjudicate guilty on the VOP, revoke and terminate, 10 months county jail, credit for all time served, $100 VOP fee, $150 cost of defense, and financials to reduce only 6 months after release.
You good with the score sheet?
Yes, Your Honor, no objection.
State in agreement with the plea.
That's the state's agreement, Your Honor.
Mr. Irish, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement, and I see you have signed the written plea agreement that contains the same terms. Have you gone over this plea agreement in
Yes, sir.
detail with your attorney? Make sure you had all your legal questions answered?
Yes, sir.
Importantly, you're waiving the right to go to a trial, you're waiving some rights by entering into this plea. Have you gone over that with your attorney?
Yes, sir.
You believe this is in your best interest to enter into this plea?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea, revoke and terminate probation, sentence you to 10 months in the county jail. You will get credit for all time served. The fees and costs must be payable within 6 months after release or it goes to collections.
Yes, sir.
Okay? Any questions?
Yes, sir.
Thank you.
Thank you.
Okay. That's the wrap for this morning. We'll reconvene at 1:30. Tomorrow.
Before I lose you, Your Honor, I wanted to ask if the court was in receipt of an evaluation that I asked to be sent for your review for the afternoon.
No.
All right, I'm gonna get that to the court immediately. I apologize, I know you wanted it ahead of
That's
time.
all right. Yeah.
It's not long, but the state stipulated.
Which case is it?
This is on Mr. Ernest Powell's case. We're set for sentencing at 2:30.
I mean, I've got several things in my packet with him. It was just recent.
I asked my staff on Thursday to send it. I think there was a miscommunication.
I haven't seen anything that
It might
I'm
have
aware
gotten
of.
sent yesterday, so
Do you have a copy of it with you?
I don't have it with me, Your Honor. This is stated.
Is it in the court file?
It's been filed in discovery, yes, Your Honor.
I mean, it's in the court file. Sometimes
Right.
it takes a few days.
But I will be back early, well before court for the 1:30 docket as well, so.
Let's just see if it's on
Okay, that's all right.
I think I just have it.
And I may be able to print one here and hand it off to the court if we'd rather before we break.
What's the case number?
It's 21 CF 415. Several things, honestly, in evaluations, notice of confidential information. was just filed March 10th. That sounds about right.
It was recently, Your Honor. I think Mr. Yates may have printed me a copy
Last 3 pages.
Yeah, it's not very long at
It's
all.
I got it.
You have it, Your Honor?
I got it. I'll pull it up when I get back to
I
my.
apologize
And-
for not getting it.
And Your Honor, I do have those score sheets at N2.
Okay.
I'm waiting on Mr. Meyer to look at his lawyer, Mr. Cheney's, but they're, for the total sum of $1.5 million. And the other one.